NFTs and the key U.S. legal considerations for this emerging asset class. NFTs are an emerging digital asset class that have captured the attention of consumers and investors alike. Although the tech that makes NFTs possible has been around for several years, NFTs have very much emerged in public consciousness in 2021. Celebrities, creators, and athletes are investing in NFT tech and exploring ways to commercialize their brand, image, or work through issuing NFTs. And while this asset class is in its nascent stages, the legal and regulatory issues they present are very real. I'll briefly discuss some relevant U.S. legal issues. Now, what are NFTs? In general terms, an NFT is a digital asset based on computer code and recorded on a blockchain ledger to prove ownership and authenticity of a unique asset. Its non-fungible nature distinguishes an NFT from other digital assets. Most other blockchain tokens are created to be fungible or interchangeable. For example, two different Bitcoin ledger entries are interchangeable, and being the holder of either allocation would give the owner the same rights as the other. Almost anything can be represented by an NFT, providing it is a unique asset. For example, real property titles, cars, houses, and other merchandise, as well as digital assets such as images, documents, videos, and tweets. In one recent case, a unique digital artwork represented by an NFT was auctioned off at Christie's for $69 million. At its essence, NFTs bring unique assets into the digital space and make ownership of that asset verifiable. In technical terms, NFTs are often created on the Ethereum blockchain through ERC-721 token standard written in the Solidity programming language. NFTs are now also being created in the EOS, Cardano, Flow, and Tron blockchains. What are some key legal considerations surrounding NFTs? The existing regulatory and legal environment was not designed to accommodate digital assets, including NFTs. Nonetheless, there are some key issues that have emerged while investors, financial services, and fintech companies and other commercial interests explore this space. Simply stated, there's no free lunch on the regulatory front for the NFTs, and this asset class also present other commercial and legal issues, many of which have current solutions but may require compromise. Will an NFT be treated as a commodity or security or something else in the US? By their nature, NFTs can be linked to a variety of different assets and represent numerous rights and obligations, making them challenging to classify. Although regulators so far have not provided official guidance about NFTs, it is possible that NFT could be considered a commodity under the Commodity Exchange Act, CEA, which defines the term to include several enumerated items and a catch-all for all other goods and articles. The Commodity Futures Trading Commission, CFTC, has also stated that the commodity definition includes cryptos like Bitcoin and Ether, as well as renewable energy credits, emission allowances, and other intangible items. NFTs share some similarities in cryptos in the sense that they are to purchase, sold, and held using blockchain technology. If an NFT is considered a commodity, the CA may apply in one of two possible ways. First, the CA's general prohibitions on deceptive and manipulative trading may apply to NFT transactions effected on a spot basis, i.e., fully funded unleveraged transactions. If an NFT is offered on a margin or leverage basis, however, additional requirements could apply, including the requirement to trade the NFT solely on a registered derivatives exchange, unless the transaction results in the actual delivery of the NFT within 28 days. The CFTC recently issued an interpretation on actual delivery for digital assets used as a medium of exchange that can be helpful in considering these issues. Looking beyond the CA, many NFTs available on the market today appear unlikely to be considered securities under the federal securities laws for a number of reasons. An NFT could be considered a security, however, if it were designed to provide an expectation of profit to the buyer based on the efforts of others and were marketed as such. One potential example of such an arrangement could be a fractional NFT, FNFT, where an investor would share a partial interest in an NFT with others. Depending on the facts and circumstances, FNFTs could be considered an investment contract under the Howey test. If an NFT or FNFT is considered a security, then common security law issues would be present. Example, registration or exemption of the offering under the Securities Act of 1933. Registration of the sellers of those instruments as broker-dealers under the Security Exchange Act of 1934. Registration of the marketplaces on which the instruments are sold as security exchanges under the Exchange Act. Securities law liability for material omissions or misstatements in insider trading. Restrictions on short sales and market stabilization around an initial offering, and so on. What intellectual property rights are transferred in a sale of an NFT? In general, the rights that accompany an NFT are determined by the seller of the NFT. NFTs contain metadata that describe the corresponding assets to which they are bound. For many NFTs available today, each asset underlying the NFT is created by someone who owns intellectual property rights in the asset and decides what rights to grant the NFT buyer. If the issuer of an NFT is a content creator, then the issuer will have all the rights in the content and can create NFTs that correspond to that content, assigning any of those rights to a buyer. For example, the right to use, copy, display, and modify the content. If an issuer obtains consent from a creator, then the issuer would only receive the rights such creator assigned or licensed to the issuer, and will only be able to assign or license those limited rights to the buyer. Common issues that could arise in the NFT transactions include ensuring that sufficient transfer, assignment, or licensing language, including any restrictions on the buyer right of use, is included in the sale to include the transfer of rights in the manner intended by the parties of the sale. Are NFTs subject to federal anti-money laundering laws, and what about U.S. sanctions? The Financial Crime Enforcement Network, FinCEN, is a bureau of the U.S. Department of Treasury with regulatory authority over the financial system to combat money laundering under the Bank Secrecy Act, or BSA, and other related laws. To date, FinCEN has not issued guidance specific to NFTs, but it has published guidance generally about the BSA and FinCEN regulations related to virtual currencies that could apply to NFTs. One question is whether FinCEN regards NFTs to be valid as substitutes for a currency. If NFTs are considered substitutes for a currency, the FinCEN could consider NFTs to be subject to the BSA and FinCEN regulations. Since many NFTs are more like digital representations of ownership in unique assets than value that substitutes for a currency, however, it seems that many NFTs available on the market should not be subject to FinCEN's oversight. Depending on the facts and circumstances, certain other business activities related to the transfer, sale, and custody of NFTs may implicate FinCEN regulations. The Office of Foreign Assets Control, OFAC, administers most U.S. sanctioned programs. Similar to FinCEN, OFAC has not provided specific guidance to NFTs, but it has explained that U.S. sanctions apply to digital transactions and currencies in ways similar to traditional activities. Further, OFAC has pursued enforcement actions involving crypto transactions and blockchain tech. The possibility of persons subject to U.S. sanctions participating or benefiting directly or indirectly from activities involving NFTs present the primary avenue of risk exposure. Moreover, NFTs present circumstances that OFAC has identified in other scenarios as presenting heightened risk for potential violations. While details will vary with different structures, the potential lack of transparency and decentralization associated with the use of blockchain tech can present difficulties in preventing sanctioned persons from participation. Further, NFTs may present many of the same issues that OFAC recently identified as associated with artwork, including a high degree of anonymity, the use of intermediaries, concealability, and subjective valuation. Given these considerations, those participating in NFT transactions could pay heed to sanction considerations. Are NFTs subject to state laws governing virtual currency or money transmission? Given the superficial similarities between NFTs and some other virtual currencies, it is reasonable to consider whether NFTs are subject to state laws governing virtual currency or money transmission. Today, no state regulator with oversight of virtual currency or money transmission has issued guidance directly about NFTs. Depending on how a particular state defines money transmission, it is possible that some may try to claim regulatory oversight over certain NFTs or certain business activities related to NFTs. In addition, some states have passed laws addressing the operation of companies engaged in virtual currency businesses. New York and Louisiana are two examples. Each state has a list of activities it deems under its law to constitute virtual currency business activities, which can include, for example, exchanging, transferring, controlling, administering, or issuing virtual currency. And both states require companies that engage in such activities to obtain a license or charter, impose surety bonds, or fund an account for the protection of customers. Depending on the characteristics of the NFT, it is possible that either state could try to apply its virtual currency law to the NFT marketplace. However, many current NFTs available on the market should not be subject to those statutes. Do NFTs give rise to unique cybersecurity concerns? As a fully digital and potential valuable asset, NFTs likely to be targeted with greater frequency by cyber criminals for financial gain. Centralized NFT marketplaces that store private keys may prove especially attractive. By obtaining the private key associated with NFT, a malicious actor can access, move, and sell the NFT without authorization from the NFT's rightful owner. And once stolen, given the decentralized and immutable nature of blockchain-based transactions, the NFT is not so easily returned. An online NFT marketplace recently acknowledged that a small number of its user accounts were compromised in so-called account takeovers, in which an unauthorized third party acquired the credentials, e.g. passwords, needed to access user accounts. The incident highlights a key vulnerability inherent in all user-facing online platforms. Users inevitably may be the most common point of compromise and are susceptible to phishing attempts, brute force attacks, and other tactics designed by malicious actors to obtain account credentials. And to mitigate the risk of loss and legal exposure, NFT platforms should consider administrative, technical, and physical safeguards, such as multi-factor authentication to better protect the security of private keys and account access credentials, need-based access controls, periodic risk assessments, and written policies that clearly document the same. The inherently cross-border nature of NFTs also raises complex issues of applicable law and regulation that may arise if NFTs are sold globally, and it should be noted that other jurisdictions already have regulatory regimes which will be relevant to NFTs, such as the EU's proposed markets and crypto assets regulation. This is a dynamic space that can be monitored as the asset class evolves, markets develop, and the law and regulations begin catching up. But enough is known about the key issues, such as those set forward, to develop careful plans for exploring potential opportunities in this space. The 4 key takeaways. 1. NFTs are an emerging asset class that have captured the attention of consumers and investors in the US, but have outpaced the regulatory and legal framework. 2. Key to understanding the use and value of NFT is the intellectual property rights granted. For example, the right to use, copy, display, and modify the content. 3. There's no direct state regulatory guidance on NFTs, although a few states have created laws that could hold NFTs under their purview. FinCEN has not issued any guidance specific to NFTs, but it has published guidance generally about how the BSA and FinCEN regulations relate to virtual currency and could apply to NFTs. And 4. NFTs likely will be targeted with greater frequency by cyber criminals for financial gain or by persons otherwise restricted from traditional markets. NFT platforms need robust controls to guard against such risk.